Hi, everyone. My name is Ida Ashuri. I'm a staff attorney with the Legal Aid Foundation of Los Angeles. I work with Legal Aid Foundation of Los Angeles as part of the LA Small Business Legal Aid Program. And today we are going to talk about contracts for small businesses. So first of all, very important, nothing in this presentation is to be considered legal advice. You should consult with an attorney if you have any specific questions regarding your issues. As well, the information in this publication does not constitute any form of lawyer-client relationship. We do provide pro bono legal assistance to small businesses, but you need to contact us so that we can screen you and make sure there's no conflicts and that you are eligible for the services. We will have a question and answer session at the end of this presentation where you can ask general questions. Please try not to ask any questions specific to you. Again, we don't want to encourage anybody to relay any personal or private information on this webinar. So if you do have personal questions about your situation, contact us, and the contact information will be at the end of this webinar. So first, the topics we will cover. We will discuss contract formation and enforceability, the terms in a contract, what happens when one party breaks a contract, as well as just some tips regarding contracts in general. So first of all, just a quiz to open up the presentation. Have you ever written a contract before? Okay. I see no one here has written a contract yet, which is you're in the right place to learn more about them. I'm sure it can be very daunting, and so it's helpful to get professional assistance. So first, what is a contract? A contract is a legally enforceable agreement between two or more parties that creates an obligation to do or not do particular things. All contracts involve an agreement, which is considered offer and acceptance, and to exchange something of value, which is called consideration. One thing, and we will discuss this many times throughout this presentation, not all agreements are required to be in writing, but generally we advise you to have all your agreements in writing. Some agreements have to be in writing by law. This list isn't inclusive, but for instance, transferring real estate, selling anything, goods valued at over $500, or contracts that require more than 1 year to perform. And when you hear 1 year to perform, that can mean from for instance, a 2-year residential lease to a warranty that on your stereo that lasts more than a year. So again, what is a contract? So you're looking at whether there is an offer, 2, acceptance of that offer, and 3, and this is the most important part, consideration. So offer and acceptance. One party must make an offer to enter into a legal relationship, and at least one other party must accept. Both parties must be willing to enter the contract and have the mental capacity to enter into and understand the terms of the agreement. So I hear sometimes people say, well, I didn't understand the agreement. Maybe English isn't your first language, or something happened. This bar is very high, so don't rely on this idea of mental capacity as a defense. So think of this as someone who's a small child, someone who might be inebriated. So don't think of that as some kind of a defense for a contract, which is another reason you should meet with an attorney and go over a contract before signing one if you can't understand what's in it. The subject matter of the contract also can't violate any laws for it to be legal. Consideration: each party has to gain some value for a contract to be legal. This helps separate this from a gift, which is completely a different thing. It could be, as little as $1, but there has to be some form of consideration exchanged. Formation. This is really about, is there a contract, period. We need to have a meeting of the minds. This is important because, and usually this is more of an issue when there isn't a written contract, or the writing is not clear. Maybe it's a series of emails and not one writing. So the court is going to look at, would a reasonable person interpret this as an agreement? And in law, a reasonable person is pretty common, but basically if someone else was looking at these emails or text messages, would they think there was a contract? So again, emails can form a contract. Text messages could be a contract. If there's a series of written documents that meets all the requirements of a contract, then you have a contract. So now we're going to discuss some terms in a contract that you might see to help you understand what's in a contract. So first, the parties. You want to have the full legal names of people who are entering the contract, not a pseudonym or a stage name, nicknames. You want to have their binding legal names. And the party can mean a person, a company, some other legal entity. You can, for instance, enter into a contract with Pepsi. You as an individual might provide some service as an actor maybe or something. You could enter into a contract with a company. When writing a contract, you want to define anything that's really important and maybe used a lot in the contract. This allows you to have clear definitions and avoid any vagueness and make sure everybody has the same understanding of the terms. For instance, maybe you enter in a contract with Pepsi regarding making a design for a bottle. Everybody might understand what bottle is differently. So you might want to define bottle as a glass bottle 7 inches in height, something like that. So that way it's defined and everybody's on the same page of what that kind of bottle is. And that's just one example. There obviously could be many. You would maybe have introductory material, which is called recitals or whereas provisions. This can tell a story about the contract, such as maybe you're in a contract because you're trying to improve a relationship with a brand, or you're trying to help a certain demographic, and you want to put that in to your contract. That's possible. Or you want to put in a story regarding the purpose of the contract, which is to transfer some residential property to one of your grandchildren. Intentions or reasons for entering the contract. Again, this isn't necessarily something you have to have, but it can help in the explanation or understanding of what the contract's purpose is. The other things are representations and warranties. So representation is more like proving that you own the things that you're selling, and warranty is not something like what you buy in the Best Buy with your new television. It's more a guarantee that you are going to deliver the item. Other things are deal terms, which are what each party has responsibility for. Obviously, if you're, for instance, selling a television, the person who owns a television will deliver it to this address at this date and time. The person buying the television will pay this amount of money by this date in this method. As well, you might want to provide information about the quality. For instance, maybe you want to mention that the television is brand new or it's used, etc. So things that you might think in your head, but you want to have the contract very explicit on each of these terms. The more detailed, the better. Some other general terms you might see in contracts that you read: attorney's fees and costs. In this instance, when you have a clause regarding attorney's fees, it usually means that if you engage in a lawsuit with the other party, that the person who loses in the court case has to pay all the attorney's fees and costs involved. So that means you would have to pay your own as well as the other parties. So it's a pretty big term, and so you want to pay attention to that if it's in something you sign. The other thing is there might be a clause regarding alternative dispute resolution. Sometimes this is just a mediation clause. It can be different things, or an arbitration clause. There's different purposes for that. Sometimes companies have that because they don't want to go to court, and they will bind you through that term to only use arbitration. Sometimes there's a mediation clause where if there's a dispute, both parties agree that before you go to court, you will try to mediate it. And that's to avoid, costly court fees and try to make it as easy as possible to try to resolve a dispute. So a mediation clause, I think, is very beneficial because you're avoiding something more expensive. The binding arbitration can be risky because arbitration often is something that the company will choose the venue and whatnot, and you may be at a disadvantage when engaging in the arbitration. And it's not like a court in the same sense that it doesn't have the same protections. And choice of law or governing law. So this can be important if you engage in business with a company from out of state. If you're in California and the company is in North Dakota and the contract says North Dakota law is binding, that means that you will have to most likely go to North Dakota if there's a court dispute. So you want to be careful and read any of those contracts for the choice of law as well. And jurisdiction, that's the same thing. So choice of law is what state's laws apply, but jurisdiction is also where the lawsuit must be filed. If you do file a lawsuit, and you will most likely have to, for instance, apply it in North Dakota. Waiver. A waiver is something that can be very significant. You can't necessarily waive away your legal rights, but especially with businesses, there's not a lot of protections. There is a danger that you waive away certain things that do give you protection. So you want to be careful about any waivers. Often in commercial leases, there's a waiver where you can't, deduct rent for any damages that might happen. So be careful and read those things, because you might think later on, oh, well, the landlord has to pay for this. But the waiver states that, no, you've already stated that you are going to have to pay for this. Severability. This is important in the sense that if there's an invalid provision, for instance, if there's like I said, a waiver that's illegal because it's trying to waive away your legal rights, the rest of the contract is still valid. And that's basically to protect whoever is writing the contract. It's an important provision. Integration, that's basically saying that everything that's in the contract itself, those 3 pages or whatever, is all the contract. And this can be important in the sense that maybe you verbally agreed to something, but it wasn't written down. It's important for you to not have it written down, actually. It causes less confusion. That's another reason why you want to have everything in the contract and not just verbally or, written on a napkin somewhere else. Notice. This is more about if there's some issues that arise. Notice can be different things, but the important thing is that the contract states, how do you deliver this notice? So for instance, in a commercial lease, there might be a provision regarding how the landlord will notify the tenant about an issue with the lease or tenancy. Like maybe there's some construction happening, maybe there's an increase in rent or change in rent. The notice provision can specify how that's going to be delivered. Residential leases have very specific rules about that, but commercial leases, courts often find that the lease itself can require different provisions than what a residential lease might require. Again, read the lease, have someone help you read it. Relationships. So this is about how each party is connected to one another. For instance, landlord, tenant, business partner, or lessee, subtenant, etc. Assignability or delegation. So maybe there's a provision in the lease that says you can't sublease, or you have a contract to provide services to someone, and it states that you can't provide those services, or no one else can provide them. Maybe you go out of town and you have a contract to provide cleaning services. This provision says you could, if you have that ability to delegate, have someone else do those services, and you would still get paid and fulfill the contract, even though it's not you personally. Limit on damages, exactly what it says. So if you end up suing or whatever, there's a limit on how much you can recover. Indemnification. This is a guarantee that if there's a third party, there's some kind of cover for any type of disputes brought by that third party. So maybe the landlord covers any disputes regarding violations of the ADA. So that's possible, but it's usually not what happens, but that's an example. Counterparts. If, for instance, you want to virtually sign something, or the fact that you don't have to all be in the same room to sign it. Force majeure, which is also called acts of God. This basically states that if, for instance, there's an earthquake, hurricane, flood, etc., that the contract will be suspended in the event of a unforeseen disaster. Okay, quiz time again. Which contract term became an issue during the COVID lockdown? Was it choice of law, waiver, or force majeure? Okay, great job, everybody. It was force majeure. Basically, people were trying to get out of their contracts, citing force majeure. Pretty valid reason. And there was a lot of, legal issues in terms of whether it applied or not. Obviously, when you have a lockdown, you can't operate your business, but you might have a contract to, supply food somewhere. Force majeure, I'm incapable of doing that right now. I don't have access to a kitchen, all these things happening. So that's what was definitely popular. Enforcing a contract. A contract is enforceable if there is some remedy for its breach, if a party fails to fulfill their end of the bargain, that's called a breach of contract. If there's a breach, one of the parties or both may wish to have the contract enforced, or may try to recover any financial losses from the alleged breach. There's different ways to resolve disputes and different what's called remedies. You could either go straight to court. This can be even small claims court to sue for breach or damages. It can be civil court. You can go for arbitration or mediation, which can be less expensive and a little bit less stressful. So the most common remedy is called compensatory damages. Basically, that's what we call making yourself whole again. For instance, if you lost a certain amount of money and you were supposed to get a television, then you would be provided the financial remedy for what you lost, and provided with that item. That's monetary damages. A court could also order someone to perform all the terms of the contract. It's not generally available, but it can be used to transfer property or unique goods. There's also something called rescission, which is generally used as for fraud. And normally that's just throwing out the contract itself and putting you back in to the original position that you were in. If you might have lost some money trying to buy the television, getting that back. There's also consequential damages. That's if there's problems with the breach. Punitive damages, that's usually when there's willful recklessness. The standard is pretty high, so that's pretty rare. Liquidated damages, there might be something in the contract specifying this, but it has to be a fair amount. So another quiz: have you ever had to enforce a contract? Have you enforced a contract in court through mediation or arbitration, through negotiation with the other party, through other means, or you have not yet? Okay. So it can be costly to go to court or even the other options, but that's why it's also important to follow these other tips, which is keep everything in writing. Oral agreements may be binding, but difficult to enforce in court. You want to have a document that clearly states all the things we discussed earlier, the terms, obligations, your rights, etc. The other thing to know is that any ambiguity or confusion is construed or interpreted against the person who writes the contract. So, for instance, if you write the contract and there's something confusing in the writing, the interpretation of that by the court will be in favor of the other person in the signing the contract, not you. So you want to think about who should write the contract to. Keep it simple. You don't want to make it confusing, because that would mean it's harder to understand and interpret. Use short and clear sentences. Numbered paragraphs can really help with organization. Headings can really help, making different sections in the contract. So to separate things out. Make sure to talk to the decision makers. You want to make sure who you're talking to can actually make decisions on behalf of the company. For instance, you want to speak with someone who has the authority to enter into a contract. If you're talking to somebody who just works in communications and Pepsi, they can't enter into agreement with you. But if you're speaking with somebody in the financial office, they would have the authority. Make sure to identify all the parties correctly. You want to have the correct legal entity names. Include all the details. Like we had discussed further, if you discuss something orally and you didn't write it down, they're not going to be able to know that. So you want to make sure everything is written down. If you forgot something, you could make an amendment, but you have to make sure that there's a provision in the contract that allows for amendments. And amendments have their own requirements. So if you have a provision that says these 3 pages are only thing that's in the contract, you wouldn't be able to write an amendment. But if you have a provision that says that you can amend the contract and it states that both of you have to sign the amendment and any other requirements, then you can amend the contract. You want to also be very specific regarding payment obligations or anything else. So, for instance, who is paying who? When should the payments be made? What are the conditions of the payments? For instance, do they have to be all Zelle or cash? Does any work need to be completed before the payments? Does payment depend on one party's satisfaction? And are they installments? You get the idea. Governing law, like we discussed before, you want to make sure it's clear what states' laws apply if you're in different states. Confidentiality may be an issue, but that's not always the case. But if it is, you want to have something written that the contents are confidential and that any party who learns about the terms, keeps the agreement confidential. And that's about it. I know there was a lot of technical information discussed, but happy to answer any questions. You can type your question into the Q&A or the chat. Okay. I don't see any questions. We do have a contact for if you want to get legal assistance. That includes us reviewing any contracts or helping you write a contract. So you can call this phone number or you can go to lalegalhelp.org. And that website also has Mandarin, Korean, and Spanish versions that you can click on a menu on the top to select a different language. And again, it's lalegalhelp.org. We'd also encourage you go to the small business project at lafla.org and follow us on social media. We will have additional webinars and we will be posting webinar videos as well as the PowerPoints online, and feel free to download those. We can't answer anything personal through any things like YouTube comments or Facebook comments. You want to contact us directly. But thank you so much for joining us, and I hope you were able to gain some information. Sure, the phone number is right there, 866-375-9511. And that is the phone number to get free assistance as a small business. Okay, well, thank you so much for joining, everybody. I hope you all have a pleasant day. We also have a webinar on Thursday at noon about knowing your rights as a commercial tenant. Please join us for that. And we should have another webinar in November, as well as a small business academy where we have a clinic. And please sign up for our emails. Thanks so much for joining us. I hope you all have a pleasant evening.